Hi, my name is Deanne Cole, and I'm an attorney with Bach Norman Law Office. And today I'd like to answer the question, why should I have my customer reaffirm in bankruptcy? When a debtor agrees to reaffirm a debt, the debtor agrees to be personally liable on a debt after the discharge in the bankruptcy case. Normally, upon receiving a discharge in bankruptcy, a debtor is relieved from any personal liability on debts incurred prior to the bankruptcy filing. For example, if I owe my attorney $200 and then I file bankruptcy and receive a discharge, that attorney is forbidden from collecting that $200 later on. If a customer reaffirms, however, the circumstances do change. When a debtor signs a reaffirmation agreement in bankruptcy, the debtor agrees that he or she will remain personally liable on the debt after the bankruptcy discharge. This usually occurs on secured debts on which the debtor desires to continue to pay post-bankruptcy. A common example is a real estate mortgage on the debtor's homestead. If a debtor expresses a desire to keep the home post-bankruptcy, a creditor should require a debtor to sign a reaffirmation agreement. If the reaffirmation agreement is signed and the debtor later defaults, the debtor is still personally liable on the note, meaning if there's an eventual deficiency, he or she will remain liable for that amount. On the other hand, if the debtor does not sign a reaffirmation agreement, but continues to pay on the mortgage and then years later defaults, the creditor is forbidden from seeking a deficiency judgment on any shortfall because of the failure to obtain a reaffirmation agreement in the underlying bankruptcy years prior. As you can see, this is a tricky area of the law, and you should seek legal advice on reaffirmation options regarding any specific situation.